Work. Good morning. Rise and shine, rise and shine. Another day, another, I don't know, stream, I guess. What's up, Karen Reed? Karen Reed? Karen, no. What's up, man? Another day, another trial. And, yeah, man, I'm going to be doing opening statements today. Opening statements, and I'm not going to be doing every day, covering all the 8 hours a day, all this stuff, because we got other stories to cover, other breaking news and things happening. But I want to watch the opening statements, see what pops off, and I think we'll probably do closing arguments. And when the verdict comes in, you know we're going to be here at the edges of our seat. Do I still have the hearing thing? Oh, did I take? Damn, I removed that. Damn. I removed that soundbite. Good morning, rising and shine. Let's watch a clip. I want to watch this clip. This is the second trial. This woman is accused of killing her boyfriend. That, you know, he was a cop. And they're saying that she hit him with her car. I gotta go get my headphones. And she's saying she didn't. And they're saying the whole town's involved, cops involved, the town's involved, forensic people involved, everybody and their mom was involved. It wasn't me. Everybody and the mama involved. Everybody.
A murder.
Oh, my audio's not. Hold up. That's right. Let me get the audio straightened out. Good morning. Where are we at? Here we go.
Her case that we couldn't take our eyes off of in 2024 is about to grab us by the neck once again. Opening statements in the retrial of Karen Reed are now just hours away in the same Massachusetts courthouse as the first trial, with the same judge, same charges, and of course the same facts. But this jury may already know those facts going in. I know you do. The police officer boyfriend dead in the snow, prosecution's theory that Reed ran him over, the defense's theory that Reed was set up by cops who had a beef with him that went too far. So who's got the stronger case going in this time round? She doesn't even have to make a case, right? But holy cow, does she ever have one? Earlier today, I spoke with Mark Garagos, renowned criminal defense attorney and longtime friend of the show. Here's our conversation about that. Mark, what's your 30,000-foot view on the Karen Reed case, part two? I feel like we've been to this rodeo before.
I thought there was a statistic, too, about people that have a second trial, right? Are they more likely to get prosecuted the second time?
And so have many people in that jurisdiction.
I'm very perplexed by this case in a lot of ways. Number one, I don't understand how the prosecution actually got a hung jury the first time around. I mean, you take a look at the evidence in this case, and it just goes to show you that jury selection is everything, because if you gave this case to most jurors would say this is the definition of reasonable doubt. So the second time around, I don't think that it's gotten better for the prosecution. I mean, if you are talking about having an investigating officer or an officer who's close to the investigation getting terminated between trial number one and trial number two, that certainly is a blow to the prosecution.
Oh, shit. Kimberly Sullivan, Connecticut. Oh shit! I gotta log in. I'm on the wrong account. Oh, I'm on my gaming account. They flipped that over. You got to cut it.
Case to most jurors. Most jurors would say this is the definition of reasonable doubt. So the second time around, I don't think that it's gotten better for the prosecution. I mean, if you are talking about having an investigating officer or an officer who's close to the investigation,
I covered that story,
getting terminated between trial number one and trial number two, that certainly is a blow to the prosecution.
And also, Karen has been able to hire a juror from round one who happens to be a lawyer. And I assume that is pretty powerful ammo.
Oh, I did that once, actually twice, where I've hired a juror from a previous case. And it is unbelievable the insight that you get from the jurors after they have sat on it. I've often said to jurors, and it's not my thought, it's theirs. When I talk to a jury afterwards, it's inevitable. It happens almost every single time that those 12 jurors who are deliberating come up with something that neither of the lawyers thought of was that important. And it was something that kind of supercomputer, artificial intelligence kind of symbiotic relationship of 12 people produces. I mean, it is really an amazing phenomenon, one of the beauties of our Constitution, because they really go deep and they look at it from a lot of different angles.
So the one thing I think of when I think of the overall information that I have learned from trial number one, from, the docuseries, and even go down the rabbit hole on any piece of social media. But the number one thing I have sort of boiled it down to is that she has a bigger, more robust case that someone else did this than the prosecutors have that she did this. That's fine when you're outside of court, but how do you streamline that and get that to the jury when you're inside of court?
Well, a lot of times the conventional wisdom is that the second trial, and I've had my share of them, so I've seen it. The second trial, the conventional wisdom is better for the prosecution.
Right.
I don't think that's the case here. I think that they have seen exactly how this has unfolded. I think Alan Jackson, and in full disclosure, I've known him since he was a young DA. Alan Jackson has the advantage here. I think if you're handicapping this, he now knows where everything is going to be. He now knows exactly what people are going to say or not going to say. That does not help the prosecution because, as you've said, there is a robust case when you tick off the items, whether it is the coroner, whether it is the injuries to others who were there, whether it's the texting, whether it's the kind of motive of the investigating officer and the horrific things he was saying about her and their predisposition, the fact that there were independent witnesses who did not see what later miraculously turned up. I just think it's as powerful a defense case as I can think of in recent.
I don't know, man. I don't agree with all that. I mean, I don't know how they're going to pull this off though with the second round, the second trial. I think it's just hard to get an impartial jury too. I don't know, and I don't know how they're able to even pull it off in that town. I had a feeling they were going to start late today too. Something told me it's going to be a while. Rufio, yeah, I covered it, I think, once or twice. Noah, back. I mean, it's been a long time. I haven't checked for any updates. Really? Bama, I passed out on your robot shenanigans. Last night was crazy on the gaming channel, yeah. That was nuts. That was nuts. Let's see what you guys are saying. Oh yeah, I don't believe this chick is innocent. No way. Karen Reed? No. I totally believe she did it. I think people that think she's innocent are like conspiracy people. That the whole town, all the cops, everybody in the house, everybody, and I feel like they just keep moving the goalpost. I didn't watch there was a documentary that she did. I mean, it was a recent documentary. I didn't watch it, but I heard people say that it made her look bad. Happiest murder defendant. She's kind of like a celebrity now. Almost like what's that girl's name? I forgot her name. I can see her in my head, but I don't remember her name. That chick that killed her mother. Yeah, we did the whole first trial. Yeah. I covered the whole first trial. Julie.
A retrial could tip the scales.
The
We're talking about Turtle Boy, whose real name is Aiden Kearney. He's a self-published blogger and arguably the most
Oh, sorry. Where's that coming from? Oh, let me mute it. Where was that from?
outspoken Karen Reed advocate. And we learned in court on Wednesday what he plans to do if he's called as a witness by the Commonwealth.
There's really no reason to beat around the bush here, Your Honor. The Commonwealth is not going to call my client, Mr. Kearney, who for the record is in the second row here today.
Can I just ask, if he were to call your client, would he take the fifth?
Yes, Judge.
Mr. Brennan, do you agree that Mr. Kearney has a Fifth Amendment right?
I think he has a Fifth Amendment privilege. I don't know that he has a Fifth Amendment privilege to all questions that we would ask, but the content that we would go into, I think he clearly would have a Fifth Amendment privilege.
All right, so you're not asking for a Lumen Martin hearing?
I'm not. I think I necessarily would have to delve into issues regarding his open indictments against a number of different victims.
Okay.
And I think there's other information that I can't discuss for other reasons because of court orders.
Okay. All right, thank you.
Judge, I would suggest that the court could take judicial notice of the 16 indictments against him.
So the Commonwealth concedes, and I believe there's a valid Fifth Amendment right.
It's important to note that Turtle Boy is the only witness in the case to take the fifth. None of the innocent witnesses that he is alleged to have intimidated have taken it. Every single one of them has testified, and they will all do so.
Yeah, I mean, he has his right to do the fifth, to plead the fifth, you know. It's interesting that for somebody that talks so much and is such a loud mouth and everything, when it comes to, you know, being a part of this and testifying, he pleads the fifth.
Again. So what does that tell you about Turtle Boy? Let's talk about it. I want to bring back.
Oh, shit. I haven't watched this clip.
Again, attorney Wendy Murphy and attorney John Phillips. Wendy, starting with you, the turtle's going to hide inside of his shell at the trial. Your thoughts?
That was a good one. Can I refer to him as the turd instead of the turtle? Because I'm trying to be as polite as I can without offending everybody in your audience. And, you know, the words that I'm thinking of using are probably objectionable. He is the most repulsive, harmful,
you guys, my bad. I thought you guys could see the video. I wasn't paying attention. I thought you guys could see the video.
Force in this case by far. Now, let's just be clear. I respect that he has a right to assert his Fifth Amendment privilege against self-incrimination. It's an important constitutional right. But what that means to us in the public is we can and should infer that he is hiding evidence that proves he committed crimes. You know, let's just be clear about that. Innocent people do not invoke the Fifth Amendment. Now, let me be clear. When I say innocent, I mean people with nothing to hide. Because as the judge made reference, and you heard it in that clip, if the prosecutor thought that his invocation of the Fifth Amendment was not in good faith, that he was just doing it as an excuse so he could sit in the courtroom and pretend to be a reporter, they would have had a hearing. The judge could have said, I find that his assertion of this privilege is not in good faith. He must testify. No, everyone in the room said, he's got stuff to hide. He's a criminal. He's got massive exposure here in terms of spending a good amount of time behind bars once he's convicted. So absolutely let him take the Fifth, but let's all understand what that means.
Yes.
He's done some very bad things in this case. He needs to take the Fifth, because if he did testify against himself, that wouldn't be good for his liberty. That's what it all means.
Right. He'd be in.
Well, I think he does have like those other cases of witness intimidation. I don't know what else he has.
Even worse trouble than he's already in. You're right, Wendy. And how about the point, I think this can't be underscored enough, that the reason he's got those 16 indictments we heard referenced are because he allegedly intimidated these witnesses, these independent people who didn't ask to be part of this case, just happened to be there that night and can offer something. These innocent people. They all testified. They all were very open in trial number 1. They're all going to testify again in trial number 2. None of them are taking the Fifth. And he's accusing all of them of hiding something. John Phillips, what does that say to you about him?
It says a lot. And he did an interview with the intelligence.
Oh, they're coming. Here we go. To me, it screams projection a bit. I don't know. I mean, I think a lot of these free Karen Reed people online are kind of weird and crazy. Stalkers, harassing people, trying to get people fired. Bunch of weirdo people.
Good morning. I see all counsel are present. I see all counsel are present. Nobody said anything to Mr. Clerk about needing to see me, but I received 4 motions over this weekend that I assume we need to at least talk about briefly. Commonwealth's motion regarding defense opening statement. I think the first 2 motions we can do quickly. I'm not issuing an order. Mr. Brennan, the defense knows third-party culprit will not be in the opening. If you think that their opening goes beyond it, you can object. Defendant's opposition to the Commonwealth's request for use of independent readers, because there's an objection, the defendant's motion's allowed. So you will not have an independent reader. Is it fair to say that the 3rd and 4th motions, Commonwealth motion to enforce compliance with court's April 16th ACCA discovery order and
what?
The Commonwealth's motion to preclude new expert testimony or alternatively to continue the trial date, that those motions will take a little bit of time, Mr. Brennan?
I don't think I'll be long in my argument.
I think that I need more information on one of them, and I think we'll do that at the end of the trial. I mean, at the end of today, we'll hear both these motions. Mr. Jackson, I did see that a list of text messages, 100 or so, is in your response to my order on Friday. Did you provide the text messages themselves?
No.
All right. In light of that and the fact that we don't have time, the juror's been waiting for some as many as 3 weeks now. I'm going to prohibit you from mentioning ACCA in your opening statement. And then we'll deal with this later today. I ordered those text messages and they weren't delivered. So we're going to be bringing the jury in. I'll be in recess for 5 minutes.
Heard on that, I think the court respectfully may be factually incorrect on a key assumption of what Your Honor is ruling.
5 minutes, Mr. Alessi.
Mr. Jackson couldn't give you the fact. I would like to hear the law.
That's more than 5 minutes. I'll see you at sidebar. Come up here.
Lord Almighty. Lord Almighty. ACCA. ACCA is supposedly the company or the group of people hired by the FBI to do an independent investigation. I thought that's how it is, right? I forgot how the whole thing goes. But there had been something that came out that supposedly they were paid by the defense. I don't know whatever ended up turning up from that. But she doesn't want them to test. I guess she doesn't want them bringing it up during the opening statements. And I always felt the ARCA guy didn't. I don't know what happened because there was a bunch of drama with the guy they call Crash Daddy. There was a bunch of drama. I haven't really followed a lot of this stuff, and so I think he ended up leaving. He wasn't he in the Karen Reed Facebook group, or his wife or something, and then they ran her off of Facebook, or she made her stuff private. I honestly felt that guy was biased the whole time. I really do. Pretending like you don't know who Karen is and all that shit. He knew who he was. The fanboy. He's in her groups and everything. He has a poster in his room. Let's see. Crash Daddy. Yeah, the Kimberly Sullivan lady, I've covered it before. I need to update it. I do need to update that story. Well, I think the thing what I've seen with Turtle Aaron is like he's shown up to these people's. I don't know if he's shown up to their houses. I seen him show up to sporting events. I saw one particular video. It was like a sporting event or something. He's just a weirdo, showing up to people, harassing people, and then they showed up to that guy's business at night after hours. Him in the glare, and they were upset that they were recorded. What the fuck? Like the people that stalk and harass are upset that this guy had a camera set up at his business and it recorded them after hour. I don't know what they were doing, banging or knocking on the thing or trying to be funny. That's why he has all those charges. Who knows what's going to happen when that goes to court? Oh, there's something happening later too. We got to cover. Oh shit, this is gonna be live. Oh, I don't even want to say yet. Hopefully this opening doesn't take too long, but I can start making a thumbnail. Oh shit, I didn't know this was happening today. Uh-oh. All right. Uh-oh. Hopefully they get to these opening statements. I remember when I was covering trials, there'd be times where I have to have my laptop right here because all the other things that would pop up, stories. Oh, the Carmelo case? Yeah. All right. So I guess while we wait, let me make a thumbnail. There is something in about maybe 2 hours. Damn, it's actually less than 2 hours. I hope this thing doesn't take all morning. There we go. Okay. Is jury coming in now? All right. They got an hour each for opening. No, Karen's been out. She hasn't been locked up. Karen Reed has been out. She has a lot of support, a lot of funding. Good morning. Mary, what's up? Yeah, Karen Sullivan has court today, and there's some other people that have court today. Carmelo, yeah, I saw Carmelo. They moved to, I guess, a secret location approved by the judge because they said they were afraid or getting threats and stuff. Even though I saw somewhere, like an article, I saw somewhere it said that the family hadn't actually reported anything to the police, like a police report for any threats. Because that's something you should do. If you're getting these death threats and you're in this type of situation, I mean, you should report it. Have stuff on record. Maybe even the police can investigate it if it gets serious enough. Or at least have something on record if you got to defend yourself. Some article said that Frisco police haven't received any reports from them. I guess I can play this in the background while.
I'm not familiar with it, but he described himself, and I got to look down, as three things. One, an activist. Okay, he said it, an activist. Two, a journalist, and three, an entertainer or satirist. Those three things are entirely inconsistent. You can't be an investigator and go through a case and have objectivity while also being an entertainer, while also worried about your YouTube hits your social media, bounce. And that's the problem here, is he's trying to wear all of these hats and one's interfering with the other. And certainly he has a Fifth Amendment right, and with an open indictment, the prosecutors certainly don't want to go into that and reveal some information that shouldn't be revealed yet. But it creates this conflict. And, again, he's a guy that wears, and markets free Karen Reed T-shirts. That's not objective. He gets exposure and he gets money from her free campaign, and yet, won't testify. It's gross where we're headed with social media and podcasters, interfering with court.
Right. You're so right, John. I have seen so much more disinformation about this case, disinformation and misinformation about this case than I have any other one I have ever covered. This has been the most vile case for so many reasons, and the victim has gotten lost. And I know you both appreciate that so much as you are advocates for victims. And when we think about what this is really about, this trial has turned into a shameful circus. It really has. And when we think about the origination of this circus, who does it go back to? Gee, Mr. Turtle Boy and his friend, Ms. Karen Reed. Now this relationship is being exposed. Your thoughts on how Hank Brennan has now made public what those two kept quiet for so long?
Yeah, really important in this case. And by the way, I know we've been saying the only person who took the fifth was this turd man, but Karen took the fifth too. Let's be honest about it, right? So the two criminals took the fifth. Who's surprised? Shit. Nobody. But one of the important things in this case that we really didn't see last time, we all thought about it, but we didn't hear it from the prosecutor per se in a way that sounded like it was going to make a big difference. Hank Brennan now is saying, part of what's going on in this case is a disinformation campaign bought and paid for by this criminal who thinks that that's a tactic that, you know, in defense attorney school, one of the things they allow you to do is just pay for PR firms and pay for protesters to show up and pay for bot farms so that social media creates this frenzy and sense that you're actually innocent and it's all a conspiracy. I mean, there are so many mentally ill people who will just buy into that regardless of the evidence. So I think what Hank Brennan's doing is making that part of his case now, saying, not only am I going to prove her guilt beyond a reasonable doubt, I'm going to prove that she was part of a campaign to mislead the public. So that's a very different approach. I was a prosecutor in Massachusetts. I've never had to do that before, both prove my case and disprove nonsense.
Right.
But we're going to hear that in this case.
Wendy, thank you for pointing that out. You're right. He's going to expose it all. He already started, and thank goodness for that, because this is just all about getting to the truth. And Wendy, John, you both, of course, know this. Our courties know. Legally, we know Karen Read is cloaked in the presumption of innocence. Hank Brennan and the Commonwealth of Massachusetts have that burden to carry. And no one, the jury, can hold it against her if she doesn't testify. Point taken, Wendy, that she's done a lot of talking to interviews of her choosing and not in the trial last time. We'll see if she changes her mind this time. Stand by for that. We'll have to leave it here for now, but great points from you both always. Wendy Murphy.
I had a feeling that because there's been so many motions and hearings and all this stuff that I had a feeling this morning was probably going to be delayed. You know, I was almost going to even set this for like later on. I feel like I would have been safe saying 10 o'clock or 11 o'clock because there's just so much with this case to follow and there's so many motions and whatever. They want to make sure because this is the second time around. So I'm sure both sides want to make sure they nail it. There's just so much information to process. So I'm not surprised at all. Not surprised at all that there's like this delay happening this morning. This is why I can't really get too caught up. That's why I haven't done a trial. I wonder what the last trial was I did. It might have been Karen Read. I don't know. Let me take a look. I haven't done a trial in a while because I can't be caught up for 8 hours straight when there's already two things happening today that I kind of want to cover, you know, so I can't really be caught up in the trial thing. The next trial that I might cover. So what was the last trial? I don't remember, bro. Oh, Alec Baldwin. Did I cover Alec Baldwin? I don't know. I think I even stopped that. The last full trial that I covered, I think, was Karen Read. That was Karen Read. And then I've just covered, I think I did opening statements for, I guess, Sarah Boone. So the opening statement, Sarah Boone. Did a little bit of Alec Baldwin. But the last full trial was Karen Read. I think I've kind of moved on from that. But I think Kohlberger, we might actually do a full trial. Kohlberger, maybe a full trial, and we did show business. Kohlberger and maybe Tupac. If the Tupac trial ever happens, those are the two trials I might have to do. And, you know, it's a little bit of negotiating or maneuvering because I have my daughter and, you know, rushing in the morning. Well, I'm always rushing in the morning, but depending what time the trial starts to get back here on time and then to pick her up in the afternoon and when is lunchtime and do we stay here for lunch or end the stream and start back after lunch? It's a lot of negotiating. And then while I'm streaming, there's chases and standoffs and barricades and shootouts, which people love to watch and cover, you know. It's too much to lock in for a month or weeks in, 8 hours a day and missing a bunch of stuff, you know? Boop, 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 boop. Wendy, which one is Wendy? Who's Wendy? Oh, the lady, is that lady over here? Is that that guy's mom? I forgot what's his name? Is that the lady here in the black hair? Oh man. Let me start this other thumbnail. Bum, bum. Hey, killer. Oh, Carmelo Anthony. Yeah. If they, I don't know if they live stream that, that would be that. I feel like that one we have to for sure do. That'd be really interesting, probably to watch. Karen. I'm assuming they're arguing the ARCA mentioning during the opening statements. All right. Let me see what else is happening this morning. iPhone 17 Pro is trending for some reason. I don't think I'm going to upgrade this time, man. They got a new sky color. Sky blue. Already talking about the different models. Here's everything leaked. New camera bump design. Glass an aluminum frame. 48 megapixel, 3.5 tetra prism telephoto. 35 times max zoom. 24 megapixel selfie. 8K video recording. 12 gigs of RAM. I have the 16 Pro. And I have the Samsung 25 Ultra somewhere. Keep losing that phone. I don't know what I did with it. The Ultra 25 already has 12 gigs of RAM, and it has like a crazy amount of zoom. And I forgot what the selfie camera is. And it does 8K. There's no real innovation anymore with phones. And the Samsung and the iPhone almost look the same. The software and shit, the home screens and all, they've become so much alike. It's different, but it's like, it's not really, I don't know. '17 Pro Max is going to be huge, and the S25 Ultra already destroyed from day one. School, when does school get out? Maddie told me today in 30 days. I think today, 30 days from today, I think. I guess in May, the end of May. School's going to be out. Summer's coming. What are you guys doing with your kids? What do you guys do did you send your kids to summer camp or part of the time? Turtle Boy, I think Turtle Boy got a lot of attention for this case, but he no longer is helping the case.
You are muted. You are unmuted.
Okay. Can we get the opening now? Please?
Hear ye, hear ye, hear ye.
Oh, I need the sound. I gotta get the sound back.
Beverly Canoni, the Justice of the Superior Court, now holding in Dedham, within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
2282 CR 117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves for the record?
Morning, Your Honor. Adam Lally for the Commonwealth.
Morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Morning, Mr. Brennan.
Morning, Your Honor. Alan Jackson on behalf of Ms. Reed.
Morning, Mr. Jackson.
Oh,
Good morning, Your Honor. Elizabeth Little, also on Happiest.
Good morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Yannetti for Karen Reed.
Good morning, Mr. Yannetti. Good morning, Ms. Reed. Good morning, jurors. So I have 3 questions I have to ask you because I haven't seen many of you for a long time, and we do appreciate that you are all here, ready, willing, and able to get started early. We sometimes have to deal with a few things before bringing you in, but we do appreciate your patience. So those questions are, were you all able to follow the instructions and refrain from discussing this case with anyone since we last saw you? Everyone said yes and nodded affirmatively. Were you also able to refrain from doing any independent research or investigation into this case?
Yes.
Everyone said yes and nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we last met?
Yes.
Everyone said no
I
or
did.
shook their heads. Thank you very much.
Jurors, can I have each of you stand and raise your right hands, please? Do each of you solemnly swear you shall well and truly try the issue between the Commonwealth and the defendant according to your evidence and according to the law, so help you God? Yes. Thank you. You can have a seat. Jurors, hearken to these indictments.
I don't think that swearing means anything for anybody.
Karen Reed of Mansfield in the County of Bristol, on or about January 29, 2022 at Canton in the County of Norfolk, did assault and beat John O'Keefe with intent to murder such person, and by such assault and battery did kill and murder the said John O'Keefe, and is guilty of murder in the 2nd degree and not in the 1st degree in violation of Massachusetts General Law, Chapter 265, Section 1. 002, Karen Reed of Mansfield in the County of Bristol, on or about January 29, 2022 at Canton in the County of Norfolk, did operate a motor vehicle upon a way as defined in General Law, Chapter 90, Section 1, or in a place to which the public has a right of access, or upon a way or in a place to which members of the public have access as invitees or licensees, with a percentage by weight of alcohol in her blood of 8/100ths or greater, or while under the influence of intoxicating liquor, and did so operate said motor vehicle so that the lives and safety of the public might be endangered, and by such wanton and reckless conduct so described to cause the death of another person, to wit John O'Keefe, in violation of General Law Chapter 265, Section 13.5. 003, Karen Reed of Mansfield in the County of Bristol, on or about January 29, 2022 at Canton in the County of Norfolk, did operate a motor vehicle upon a way or in a place to which the public has a right of access, or upon a way or in a place to which members of the public have access as invitees or licensees, and without stopping and making known her name, residence, and registration number of her motor vehicle, to go away to avoid prosecution or evade apprehension after knowingly colliding with or otherwise causing injury to John O'Keefe, such injuries having resulted in the death of said person in violation of General Law Chapter 90, Section 24, Subsection 2, Subsection A.5, Subsection 2. To these indictments, the defendant has pled that she is not guilty and for trial has put herself upon the country which country you are, and you are sworn to try the issue. If she is guilty, you are to say so. If she is not guilty, you say so and no more. Jurors, hearken the evidence.
All right. Thank you. All right, members of the jury, I'm about to make some preliminary remarks to you to acquaint you with some of the legal principles, procedure, and terminology that you may inquire during the course of this trial. These comments are not intended to be a substitute for the more detailed instructions on the law that I'll give you at the conclusion of the case. So you'll remember that this is a trial of a criminal case. Ms. Reed is charged with second-degree murder. She's also charged with manslaughter while operating under the influence and leaving the scene after causing personal injury or death, the indictments that Mr. McDermott just read to you. I'll describe the law in detail at the end of the case and the elements of these charges, but briefly, murder is the unlawful killing of a human being. In order to prove Ms. Reed guilty of second-degree murder, the Commonwealth must prove beyond a reasonable doubt that she committed an unlawful killing and that it was done with malice. In comparison, manslaughter while operating under the influence is an unintentional, unlawful killing caused by wanton or reckless conduct while under the influence of intoxicating liquor. And leaving the scene of an accident after causing personal injury or death requires the Commonwealth to prove that Ms. Reed knowingly collided with John O'Keefe, that she caused him injury or death, and then she fled the scene. These terms and the elements of the crimes will be explained to you in detail at the end of the case before you begin your deliberations. Now, please remember that Ms. Reed starts this trial presumed to be innocent. The fact that she was arrested or that she was indicted is not proof of anything. An indictment is just a piece of paper. It just makes an accusation. It is merely a formal manner of accusing a person of a crime and bringing that person to trial in the Superior Court. But it is only the jury, in other words, you folks, who can decide whether the prosecution has proved its case beyond a reasonable doubt. If the Commonwealth does not do that, then the presumption of innocence alone requires you to find the defendant not guilty. The law never requires a defendant to prove her innocence, to produce any evidence whatsoever, or to do anything other than attend the trial. This presumption of innocence remains with the defendant until you, the jury, make your determination after listening and considering all the evidence. Now, what is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent until he or she is proved guilty, and that the burden of proof is on the prosecutor. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty.
What you guys think, man? You think this time around, will they find her guilty, or will she be found not guilty on all charges, or are they going to have a hard time again? The jury?
This is what we mean by proof beyond a reasonable doubt. Now, our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You have agreed to be fair, and I am sure that you want to be fair, but that is not always easy. One difficulty comes from our own built-in expectations and assumptions. They exist even if we're not aware of them and even if we believe we do not have them. Some of you may have heard this called implicit bias, and that's what I'm talking about. Of course, we judges have the same problem as everyone else, so let me share a few strategies that we have found useful. First, slow down. Do not rush to a decision. Hasty decisions are more likely to reflect stereotypes or hidden biases. Second, keep an open mind. Avoid drawing conclusions until the end of the case when you and your fellow jurors deliberate. Remember that when you deliberate, you will have all the evidence and all the time you need to make a careful decision. So there truly is no need to start making up your mind before then. Third, you should listen closely to all the witnesses. That is the best way to ensure that you decide this case based on the evidence and the law instead of upon unsupported assumptions. Fourth, as you listen to the testimony about the people involved in this case, please consider them as individuals rather than as members of a particular group. And finally, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? At the end of the case, I will remind you of these strategies and ask you to focus on the evidence instead of any unsupported assumptions you may have. All we ask is that you, individually and as a group, do your best to resolve this case based upon the evidence and the law, without sympathy, bias, or prejudice, to the best of your ability as human beings. Now, when I finish these initial instructions, the Commonwealth, Mr. Brennan, will make his opening statement. Then Ms. Reed's lawyer, Mr. Jackson, can choose to make an opening statement or not, because, again, remember, the defendant has no burden of proof and doesn't have to prove anything. Her lawyer does not need to make an opening statement. An opening statement is a summary of what the lawyer expects the evidence at trial will be. It is intended simply to introduce the main issues in this case to you. Next, the prosecution will introduce evidence in support of the charges in the indictments. After that, the defendant may present evidence on her behalf if she wishes to do so, but she is not obliged to do so. Remember, the burden of proof is always on the Commonwealth to prove that the defendant is guilty. The law does not require any defendant to prove her innocence or to produce any evidence at all. After all the evidence, each side will have an opportunity to offer you closing arguments about what conclusions you might draw from the evidence. Like the opening statements, the closing arguments are not evidence. They're merely intended to help you understand the respective contentions of the parties. Finally, after all the evidence and the lawyer's arguments, I will instruct you in detail on the principles of law which you are to apply in your deliberations when you retire to consider your verdict. Your verdict must be...
The thing is, okay, so you say, you guys say do a poll, but I'm wondering how to do it, because I can't just say guilty or not guilty, right? Because there's 3 different charges. Because I think, just my opinion, and I know a lot of people disagree and everybody has different thoughts, I think that they should, in the very least, be able to get vehicular manslaughter while intoxicated and leaving the scene of a collision resulting in death. I think those two, the second-degree murder, might be hard. I say that because I do feel, when I watched the first trial, they made some mistakes throughout the investigation. I think they could have done a better job, So maybe that second degree might be hard. I don't know, pull that off. But I think at the very least, they should be able to. First of all, definitely the third. But I believe second and third, they should be able to find her guilty on those. Because the first trial, what was it that the jury was disagreeing about? They all felt she was not guilty for second-degree murder, but was it like the vehicular manslaughter they were arguing? I haven't followed up or followed the whole thing after with the jurors that supposedly came forward. Caleb, thank you so much for the 10. Appreciate that. Hit the like and share stream, y'all. Gotta get Auntie Bev Mel off to a good start for round 2. I'm only doing opening statements. I'm not going to do the whole trial. There's plenty of people covering the whole trial, though. I'm just doing opening statements. I'll probably do closing arguments. And when the verdict is in, I will be here. Maybe with the wig on. I might have to have a shot. I don't know. I haven't drank. It's been almost 3 months. But if she's found guilty on all three, I might have to have a shot ready to go. We could do some shit like that. I don't know. We have to see.
This happens a lot. You'll find this during the course of the trial.
They still haven't figured it out.
If I let the witness answer the question, but you're not allowed to give the answer any more weight than you would have no objection had been made. Please do not hold it against the lawyers if they make an objection. That's the important part of the lawyer's job. The lawyers have to let me know when there is a potential issue about the admissibility of certain evidence under our law.
Kayla, thank you for the tip.
You must decide this case solely on the evidence presented in this courtroom. This will include the sworn testimony of witnesses and may also include any exhibits that are admitted into evidence, any facts that I tell you have been agreed to by both sides, and any facts that I indicate to you may be taken as a matter of common knowledge. Questions to witnesses, no matter how artfully phrased, are not evidence. Only the answers which you receive from the witnesses who are testifying under oath are evidence. So, if a witness is asked, isn't it true that after you learned that your uncle left you money in his will, you poisoned him? And the witness's answer is no. Based solely on that question and answer, there is no evidence that the witness has an uncle, that the uncle had a will, that the uncle left the witness money, that the witness knew that he did, or that the witness poisoned him. Any information that you may have read, heard, or seen about the case outside of the courtroom is not evidence. My instructions to you and any other comments I may make, the lawyer's openings and closing arguments, and any comments they may make are not evidence. I will emphasize this point because it's crucial to your understanding of your role. If the lawyers or I make any comments during the trial, those comments are not evidence, and your verdict must be based only on the evidence. In Massachusetts, lawyers are not allowed to make comments other than during opening statements and closing arguments. They are permitted only to ask questions, but they cannot comment on the witness's answer. If a lawyer comments, you are to disregard it. I will emphasize in this way, communication in the courtroom is not like everyday conversation. If a lawyer seems to agree or disagree with an answer, or if a lawyer expresses confusion or any other reaction or emotion, you are to give no weight to what that lawyer does. In the interaction between a lawyer and a witness, you may consider only the witness's testimony as evidence. In a similar way, any comment I make is not evidence. But of course, you can't disregard what I say when I provide you with instruction or direction. Remember, however, I'm the only one who can instruct you or direct you in any way. Finally, on this topic, if one of the lawyers or I refer to some part of the evidence and that does not coincide with your own recollection, it is your collective recollection which you are to follow in your deliberations. Now, in this case, I anticipate that we will go by bus to an area that you'll hear about during the trial. You may consider as evidence anything that you observe about the layout of the area, including the scene of the alleged crime when we do go there. I will give you further instructions prior to our leaving for the view. Now, in this case, I'm going to allow you to take notes. Any jurors who wish to take notes during the course of the trial, except during opening statements and closing arguments, because remember, those aren't evidence. If you wish to take notes, you may do so once the evidence begins. Notebooks and pencils will be provided to you. The notebooks will be collected each day, and they'll be locked up, and they will remain confidential, and they're destroyed at the end of the trial. Nobody sees them. You're not required to take notes. The choice is entirely up to you. Some jurors may feel that notes are helpful, particularly if the case involves many witnesses or complicated issues. Notes also can help you remember specific testimony or evidence, such as times, places, dates, dates, names, relationships, events, distances, things like that. Other jurors may feel that note-taking is a distraction and may interfere with hearing and evaluating the evidence. If you do take notes, I suggest you keep them brief. They are not and cannot be considered official transcripts of the trial testimony.
Oh, so they allow
However,
notes. Okay.
bear in mind that although the court reporter is recording everything that transpires here, we do not have the capability of providing you with a transcript of the testimony at the conclusion of the trial. So you'll have to rely on your own memories of the testimony, perhaps supplemented by your notes. Regardless of whether or not you take notes, please remember that how a witness testifies may be just as important as what he or she says. Therefore, your observations of the witness's appearance and demeanor on the witness stand may play an important part in your assessment of his or her credibility. Do not let note-taking distract from an appreciation of all the evidence. If you have any trouble hearing or seeing during the trial, please raise your hand or let a court officer know, and we'll make any necessary adjustments. We generally take a morning recess at around 11 o'clock or so, but if you need a break at any other time, please raise your hand.
Damn, I'm wondering if today, I don't want opening statements to be an entire day. Because I'm wondering if they're just going to be able to do one. The prosecution, who goes first? I guess the prosecution. I wonder if they'll be able to do one, and then they're going to take a break, and then they'll do the other. Shit, man. I ain't got all day for this. I ain't got all day for this shit.
Famously said that we are a government of laws, not of men, and that the law must be deaf as an adder to the clamoring of the public. He meant that while public opinion about a given subject may ebb and flow, the law must be steady, reliable, and even-handed.
So this attorney is claiming that they're not allowed to talk about ARCA witnesses or third-party culprit during their opening statement. He's saying this is a devastating blow for the opening statement.
Where the evidence is contested, you will determine where the truth lies. Ultimately, this jury will decide whether the Commonwealth has carried its burden of proving that the defendant is guilty of any crime beyond a reasonable doubt. People outside of this building have rights, and we know that they have voices, but this trial will be decided by you, an independent jury, free from outside interference, based only upon the evidence presented in this courtroom and the law. This is the only way to ensure that every person who comes before the court receives a fair trial. It is just that simple and that important. So while public comment will likely continue, you must ignore it so that the rule of law will be upheld. Which leads me to the fact that it is very important that during this trial, until you deliberate, you must not discuss this case with anyone. This includes your family and friends, and even your fellow jurors. Nor should you allow anyone to communicate with you about any specific aspect or any aspect of this case. You must not conduct any independent research about this case, the matters in this case, and the individuals involved in this case. In other words, you must not consult the internet or do anything else to try and find out information from any source outside the confines in this courtroom. Please be very careful with your social media use. Please do not use X or Twitter, Facebook, Instagram, or Reddit. Though you may never have seen anything about this case before on your social media feed, you cannot control what may pop up. You should also remember.
Wow. Wow. Yeah, I could have started this shit at 12. I'm curious. I do want to hear the opening statements. I'm a little curious just to see what the prosecution and what the defense will say. You know, just to see what they're going to lay out. I'm curious to hear that.
To the grocery store, guys are I guess I'm passing.
Wow.
So all of a sudden when I go to the grocery store, guys are I guess I'm passing because guys are being really nice and they're flirting with me and stuff.
Oh shit.
And I really like it.
Ooh.
And I thought maybe I should be oh, be careful, I'm a trans woman. But now it's I'm not dating them, you know, there's this one guy who all of a sudden started pursuing me, a really handsome guy. And like, I told him that I'm a trans woman, you know, so I couldn't hide it, right? But like, I'm 5'2" and I weigh probably like 140. I was 130, but they told me that I should gain some weight for my boobs and my butt. So like now I just eat whatever I want, which is terrible.
Okay, she flexing. Okay, flexing. Go girl, flex it. A lot of men are walking up flirting with her, asking to get married. I love you. I'll do anything for you. Damn, okay, so I'll see you.
Thank you.
Are we ready? Are we finally ready? Finally ready. Let's go. This is Brennan. Let's see what he has to say.
At 6:04 a.m. on January 29, 2022, the alarm bell sounded in the Canton Fire Department. Firefighter paramedic Timothy Nuttall knew what that meant. His heart skipped a beat. He raced to his equipment and he picked up his bag, which was meticulous. There was a sign and a signal, and then there was a voice commanding that there was cardiac arrest. The most serious of calls for a firefighter and paramedic, that means that a person's heart has stopped. He didn't know who it was, he didn't know where it was. He took his bag, he had just gotten to the station, and he rushed to the ambulance. He was one of the most senior paramedics that morning. Another paramedic, Anthony Flamati, would be running this mission. He jumped in the back of the ambulance, the door shut, and they headed off to 34 Fairview Road. As they drove, firefighter Nuttall could not see anything. He couldn't hear anything other than the engine of the ambulance. He could feel it sliding across the road. It was near blizzard conditions. He calmed himself, he steadied himself. This is what the firefighters and paramedics are trained to do, to focus. And he focused on his task. He looked around the back of the ambulance to make sure all the tools were in place. The ambulance was meticulous as well. This was Anthony Flamati's ambulance, and it was well stocked. He calmed himself, and he thought about what was going to happen. What should he be looking for? What is his next steps? He played the scenarios through his mind, and every calm was above him. As the car pulled up to 34 Fairview, the ambulance, he stood at the back door, the doors open, and he stepped out into bedlam. He could hear a woman screaming and shrieking, the cold, hard air slapping on his face, and the wind, blizzard conditions swirling around him. You will hear him tell you how he trudged towards those screams in the darkness to snow, and when he got there, he saw 3 women surrounding a man lying, not moving on the ground. He walked up to the man, and he reached down, and he tried to find any signs of life, pulse, anything, and he found nothing. And he got up and he walked over to the woman, and he walked over to that defendant, Karen Reed, and he told her that he thinks that that man is gone. And then he heard the yell from Anthony Flamati, the chief, and he said, "Come back, let's go." Because you'll learn that in the cold, even if somebody's heart stops, even if they're presumed to have passed, sometimes you can still save a life. So you'll see on a dash cam video, you'll hear through testimony, he went back to that man, who's John O'Keefe. He went back to him, and that crew, coordinated effort, they did everything they could to save his life. They got on their knees, they began CPR, and firefighter Nuttall will explain, as he knelt over John O'Keefe, he looked up, and the defendant approached him, and you'll see it on the video. Now, he wanted any information, because when you're trying to save someone, you want to know, are they on drugs, medication, do they have a heart condition? And he looked up at Miss Reed, and he said, "What happened?" And you'll hear her words to firefighter Nuttall. She said, "I hit him, I hit him, I hit him." And it was at that time, through the words of the defendant, that she admitted what she had done that night, that she hit John O'Keefe. Now, those words didn't mean anything to firefighter Nuttall. They weren't in context. They didn't reconcile with the injuries. They didn't help him in his treatment, so he ignored it. Now, firefighter Nuttall is not a police officer. He is not an investigator. He is not a detective. He's a first responder. And so he takes that information. It was useless to him. He continues to work on John O'Keefe, trying to save his life. You'll see the team put him on a stretcher. And when they lift him from the ground, even though there is snow accumulating, underneath John O'Keefe is simply grass, hard, brown, frozen. And beneath his body lay his cell phone. They bring him to the ambulance, and while they bring him to the ambulance, you'll see on the videos that other first responders speak to the defendant. One first responder, Mr. Flamati, she will say, I hit him, oh my God, I hit him. And then she was interviewed or asked questions for background information, not a criminal investigation, just background to try to help John. And she was asked questions about his background, and during that conversation, you won't hear her see the defendant was a person by the name of Jen McCabe and a firefighter McLaughlin. And she tells Fire McLaughlin, the third first responder, I hit him. They bring Mr. O'Keefe to the Good Samaritan Hospital, and his body is cold. The doctors work feverishly. They treat him, trying to save him. They try to warm his core. And unfortunately, firefighter Nuttall's first instinct is accurate. John O'Keefe passed. So why are we here today? We are here today because John O'Keefe was killed by the actions and conduct of that defendant, Karen Reed. You will learn through this case, through facts, science, and data, you will learn that on January 29th, 2022, when the defendant and Mr. O'Keefe were in front of 34 Fairview Road, all the way to the left side in that dark corner near a flagpole, you will learn that Mr. O'Keefe got out of the car. He got out and he stood by the side of the road after an argument with the defendant. That argument, that anger fueled by heavy intoxication, you will learn from the science and data as he stood by the side of the road, the defendant and her SUV drove away. She drove at least 35 feet away. The argument was over. It had ended. But then she stopped. She stopped. She put the Lexus into neutral, and she waited for 2 seconds. And the facts and the science and data will tell you that despite the fact the argument was over, she then put the Lexus into reverse, put her foot on the gas pedal, and began to press. Not 25%, not 50%,
100%?
75% acceleration. There was a light dusting of snow. The Lexus tire spun backwards. She went backwards at least 70 feet. She clipped John O'Keefe. He fell backwards, hit his head, broke his skull. And there he lay at the corner of Fairview Road, on the ground, lying on top of his cell phone, alone. And then the defendant will later tell that when she left, he didn't look mortally wounded. Yet he was. And she simply drove away. Now, before I tell you about the data and the facts and the science, and I walk you through that, I'd like to tell you a little bit about John O'Keefe. John O'Keefe was a young man, a local kid, very well liked, loved. John O'Keefe is the son of Peggy O'Keefe, John O'Keefe Sr., and the brother of Paul O'Keefe. Grew up in Canton, worked hard, he became a police officer. But what you're going to learn, the fact that he worked for the Boston police officer, as a Boston police officer, was just a fraction of his life. It was a small, really unimportant part, because the biggest part of John O'Keefe is he was a family man. Not in the traditional sense. You see, John O'Keefe never had biological children. John O'Keefe was never married. But John O'Keefe had a sister, and she had 2 children. And when the children were 6 and 3 years old, his sister unfortunately died. And shortly after, his sister's husband died. John O'Keefe was a helper. He didn't sit by. He saw these two recently orphaned children, and he stepped in and he said he was going to raise them. So he put aside his career, he put aside his job, and he moved in with the children and raised them like they were his home. They were his passions, his love. He was a new parent, successes, failures, like all parents. And he raised the children with the help of people in the community, with the help of his brother, with the help of his family. And they led a good life. Enter Karen Reed. Around COVID, the defendant and Mr. O'Keefe reacquainted, and they started a relationship. And you'll hear that even though the defendant had her own home, she was staying with Mr. O'Keefe a lot, 4, 5, 6 times a week. And to most of the world, it was a pretty good relationship. They spent time together, they did activities with the children together. She helped with driving the children, feeding the children. It was a steady relationship.
From the outside, I think it seemed okay.
Until about the beginning of 2022. And then things began to unravel. There was tension. There was arguments. In fact, just a few days before this incident, you'll hear that Mr. O'Keefe asked her to leave. But she wouldn't. You're going to be able to read text messages of their conversations on January 28, 2022, and you will see the tension and the unraveling of the relationship. You will read about the discord between the defendant and Mr. O'Keefe. You will see that when he would ignore her calls, they would become incessant. When he would try to push away, she would come closer. You will read those text messages and you will realize that this was the beginning of the end of this relationship. That night, they decided they would go out together. I want to tell you something about data and science before we get to that night. I mentioned that underneath John's body was a cell phone. A cell phone is an amazing piece of technology. It is like a computer. It carries extraordinary data. And when they found the cell phone, the only companion to John O'Keefe that night, they studied the cell phone, and there'll be some remarkable data that you will use in this case to find the truth. I want to mention 3 different things you will find in a cell phone that are critical to this case. The first is called location data. Waze we've all heard of, Google Maps. Well, at some point that night, John put his Waze on. And Waze is like a breadcrumb that will show exactly where the phone goes, second by second. It is the strongest, most accurate location data that you can have. And that night, John was using Waze. It also will have healthcare data. Healthcare data will show when somebody is moving. Sometimes it's qualified as steps, but it doesn't necessarily mean somebody's stepping. Moving their arms, walking, turning. It doesn't show what direction or how far, but it shows movement of a person. Okay. And the third thing, remarkably, will be an expert in this case who found a data file on the phone, and it tracks the temperature of the cell phone battery. That will be critical to your analysis in this case, the temperature of the cell phone battery.
Did they bring that up the first time?
That,
I don't know. I don't think they
I
did.
want to take you back to the timeline of that night. After the discord, both the defendant and Mr. O'Keefe decided they would meet at a bar called McCarthy's. Now, McCarthy's is a local bar, a blizzard is pending, and people are getting together in a celebratory mood. They go to McCarthy's, and you'll see a video of McCarthy's, and you will watch both Mr. O'Keefe, friends, and the defendant drinking alcohol. And you will count 8 vodka drinks that the defendant drank. They arrived at 8:50, they stayed till 9:45. She consumed at least 7 of those drinks in less than 2 hours. The last drink, you'll see when they leave the bar, she puts it under her jacket, and they walk out and they go to another bar to meet other friends called the Waterfall. They reach the Waterfall sometime around 10 p.m. And when they go into the Waterfall, you'll see a video. And when I said celebratory mood, you will see a group of friends of John O'Keefe, many who are friends with Karen through John, and you'll see them clapping and happy and joyous that they're there. You'll see many hugs between John O'Keefe and his friends and the defendants and many of the people.
I can't wait till they pause.
Spend some time together, they're drinking, and they all do a shot. And that will be at least the 8th drink within 3 hours that you consume. You will see from the data, not just the cell phone data, but there's some other very important data. And the other piece of data that goes hand in glove with the cell phone is information on the defendant's Lexus vehicle chips. You might have heard of black box in an airplane, where there's some type of event that captures a small amount of time. Well, that was captured in the defendant's Lexus. That black box information with the cell phone data will tell you everything you need to know in this case. It will bring us step by step through the entire night to the death of John O'Keefe. And so they leave the Waterfall Bar at 12:12, and you'll see that the ignition goes on to the defendant's Lexus. And both John O'Keefe and the defendant in the car, and they decide that they're going to go back to 34 Fairview Road, where we talked about earlier. They're going to go there for a get-together for one of the homeowner's sons who's having a birthday party. And so as they drive back, we'll be able to follow them with this location data. When they go back to Fairview, they don't know exactly where it is, and they get lost. And so John O'Keefe makes a phone call, has a phone call with one of his friends, Jen McCabe. And during that phone call, which the defendant listens to because she recounts it, and trying to get directions, Jen McCabe tells John O'Keefe it's near Bella's mom's house. You'll learn that Bella, or her mom, was somebody that John had dated before the school. And so as they make their way to Fairview, you will see there's a road that comes down like a loop and that leads to Fairview. They take a wrong turn on the loop, and then they do a 3-point turn in the driveway. You'll see the exact precise driveway they turn into because some type of acceleration movement triggered that black box in the Lexus. And that's important because that's 7 minutes before the collision. And you'll see from the waves exactly where the car was. You'll see from the black box the event of the 3-point turn in the driveway, and then a return down to Fairview. But before they get there, at 12:23, a truck is coming the other way. And the witnesses in that truck will say they blinked the lights. One of them saw a man and woman in the car, John and the defendant, and then they followed the Lexus because they were going to the same house. The truck stopped at the driveway, and the Lexus, the defendant's car, will appear because of the waves and be counted second to second, never stops. It rolls very slowly all the way to the end of the yard in the corner where there's a tree line and a flagpole. And they reach that location at 12:34:33. And they're in the car and they stay there. The truck waits, they speak to somebody in the house who comes out, the person goes back in the house and they're there for about 5 minutes. We're now down to 2 minutes before the collision. The truck leaves, and now it's just the defendant and John. And while they're waiting outside, 12:27, John gets a text from Jen McCabe. Park behind us in the driveway. 12:29, she texts again. Are you coming in? You'll hear that Jen McCabe and others look out the window and see the defendant's Lexus in front of the flagpole at the far end. It's snowy, it's dark, it's windy, they're waiting. You will know that John O'Keefe was in that car, that Lexus, and didn't move because his healthcare data is not moving. It's not moving until 12:31:56. At 12:31:56, he begins to move. He will have 20 seconds before he falls. 20 seconds. He gets out of the car, the Lexus, and in that 20 seconds, you'll hear that user initiated. He looks at the phone, at the text message to Jen McCabe. It's now 12:32:09. He closes the phone the last time. It will be the last time he uses that phone. From the waterfall bar, you see that he keeps it in his back pocket. And at that time, 12:32:09, last user, he has 7 more seconds he will move before he lied dormant the rest of the night. We'll also have the information from the defendant's Lexus black box. The clocks run differently. There's a 30-second variance, but it's right in the heart of that time. And you will see through the data at that time, when he makes his last movements with the phone, is when her car leaves 34 feet at least, stops, neutral, and then shoots into reverse with the tires spinning right towards him, right where he got out. You'll know they're arguing because the next morning she tells the firefighter, I'm sad because our last moments were fighting. She drives away. They said she's made later statements that when she left he didn't look mortally wounded. He lied on the ground on top of his phone, light dusting of snow, the snow now picking up. And he was just there. It's 12:37. Now, when he's in the car, before he gets to Fairview, the battery temperature of that phone is 77 degrees. 77 degrees in the warm car. Now that he's been outside the car for 5 minutes, drops.
Uh-oh. Yes! All right, guys, we're going to do a different stream now. Just kidding. What happened?
She calls again at 12:36:33 and leaves a message. You'll hear it. And you will hear the anger and rage in her voice. She leaves a message. John, I fucking...
Oh, they're having problems today. Is that just law and crime? Well, duh. It's not me this time, guys. Yeah, I honestly don't even want to be stuck with this thing. I get antsy because I'm worried about what kind of breaking news could come right now while I'm stuck here streaming this shit. How do you guys think he's doing so far? And why are we frozen? What's happening? Yes! See you guys. Bye. Bloop. Out of here. Fuck this shit. 28% say second-degree murder. 32% say vehicular manslaughter, and 40% say innocent.
Cell phone drops to almost 60 degrees. 12:59, the defendant leaves another message.
Oh boy, what's going on this morning? Maybe too many people watching? Can't be. Maybe we have to try a different news channel. I'm surprised. I am surprised. How's Court TV? Let's see.
Battery temperature, 61 degrees. So, he gets almost 40 calls from the defendant.
Wow, 40 calls?
But he never answers. You'll hear from an expert that the light never initiates, the healthcare data never holds. He's John alone with his only companion, his phone. At 12:53, cell phone drops to almost 60 degrees. 12:59, the defendant leaves another message on John's phone. Now, she hasn't spoken to anybody. Nobody has spoken to her. But her message is telling. You'll learn the message says, John, nobody knows where you are. And this is where the plot in the cover-up begins.
Oh.
The evidence will make clear that she knew he was there. But she did not call 911. She did not go back to him. She did not leave an anonymous.
Look at her face, too. She's looking the whole time.
The night wears on. It's now 1:07. Battery temperature 55 degrees. 1:14, she calls her mother. No answer. 1:14:53. Battery temperature 50 degrees. The defendant had healthcare data on her phone as well, and you'll hear that it stops around that time. And you'll later learn that she admits to falling asleep and passing out. But then she wakes. 5 o'clock, she is frantic. She wakes up John's niece, and she is unintelligible. She is yelling, she's screaming, she asks for the niece to call Jen McCabe. She calls Jen McCabe, and you'll hear Jen McCabe recount. Out of a deep sleep, she wakes up and she hears, Jen, 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 screaming Jen's name. John's dead. Hangs up the phone. Jen McCabe calls down. And then she's, what's going on? And she's told, well, I left him at the waterfall at the beginning of the cover. She tells Jen McCabe, I left him at the waterfall. Jen calls back and says, "We saw you up front. You did leave at the waterfall." She hangs up. She then minutes later calls another person, Kerry Roberts, a friend of John O'Keefe. Someone who's not friends with the defendant, but they know because they helped raise the kids and they interacted. She had nothing to do with the night before, wasn't at the bars, was home with her family. She calls her and says, "I think John got hit by a plow. I think he's dead." Now, Kerry, with that information, calls 911. She calls hospitals. You can hear her voice. She's concerned, not panicked. And then she gets another call from the defendant. And she tells the defendant, "Come to my house. I will help you look for him." And the defendant says, "I was so drunk last night, I don't remember anything." Waiting for her to arrive, she learns she doesn't arrive. Instead, the defendant goes to Jen McCabe's house. Kerry Roberts, the other friend, then goes to Jen McCabe's house, pulls behind the car. And when she does, she's on Bluetooth, and she can hear the defendant say, "My taillight's broken, my taillight's broken." And she looks, and the snow packed in the right taillight, she can see a piece of the taillight missing. The defendant desperately wants to go to 34 Fairview Road, but Kerry Roberts takes over and says, "We're going to go back to John's house. Maybe he's in the house and you didn't see him." So both cars, driven by Kerry Roberts and then Jen McCabe, with the defendant, go back to John O'Keefe's house. You'll see a ring video where you see them go into the house and they look around, and you'll hear about the woman, Jen and Kerry, enlisted into this task. Look for John O'Keefe. They cannot find him. And then when Kerry Roberts comes into a room, she sees, rather than looking, the defendant simply standing there, staring at the wall. At that point, the defendant insists they got to go back to Fairview Road. They decide they'll take one car. Kerry Roberts is taking charge. She's going to drive. They leave Miss Reed's Lexus in John O'Keefe's driveway, and they drive back towards 34 Fairview Road. You'll hear it is blizzard-like conditions. It is dark. They can barely see a thing. And when they get close to the edge of 34 Fairview,
screams out and
you hear
sees
the
his body.
defendant start to scream, "There he is!" Both women look and they can't see anything. She starts kicking the door. The defendant's kicking the door. "Let me out!" Kerry Roberts stops the car and lets
you
her
know he
out,
was
and
there.
she sees the defendant run exactly to where John O'Keefe is in the darkness. Just where she left him. Kerry gets out of the car, starts to walk towards where the defendant is, and she sees the defendant lying on a body. She can't tell who it is because the face is still covered with snow. And she comes over and looks, and she wipes off the snow from John O'Keefe's face. She realizes it's one of her best friends in the world, is John O'Keefe. And she starts to try to do first aid. They start to move him, and coincidentally at 6:06 when they start to move him, the cold air hits that cell phone battery. It drops from 50 to 43 degrees. And they try, Jen McCabe calls 911. And that's when a police officer arrives, firefighter Nuttall and his crew. And when they lift him, that cell phone battery that is shot down to 37 degrees, Kerry Roberts picks it up and puts it in her pocket, and it immediately starts to warm. As she moves, the healthcare data showing movement starts again. At that point, nobody knows what happened. The Canton Police Department come. You can see the police cars and cruisers. They're not sure, so they look in the area where John's body is and they find a glass from the bar near his body. They find blood spots. They try to put the blood spots in plastic containers. They don't know what they're looking for at this point. There's no information. They don't believe or know that there's a crime. They just know that John O'Keefe somehow ended up here with the broken glass and the blood. And so that morning, you can see the work of the Canton Police Department try to uncover a little bit around his body to see what they could find, which was very little. And then, Kerry Roberts goes and picks up Peg O'Keefe, tells her the news, and they go to the hospital. They go to the Good Samaritan Hospital, and Kerry Roberts is walking, and Peggy O'Keefe is going to go see her son with her husband. And as she walks down the hall, Karen Reed is also at the hospital. See, there was some reports of
Austin is
upset or suicidal, so they sectioned her. They put her in for evaluation to make sure she was safe. You'll hear Peg O'Keefe tell her she walked down the hall to go see her son. The defendant was screaming, "Is he dead? Is he dead?" As she walked by Karen Reed, she stopped and she said, "Karen, what happened?" And you hear that Karen was excited and yelling, he's dead. Stops her excitement. Becomes stoic. Doesn't say a word. Peggy pays respects to her son, and then she has to go back home because she has to tell the children. Now, while she's out, the Canton Police Department send an officer to the house to make sure the children are safe because they're alone if they're home. And when the officer pulls in, he doesn't notice anything, but you'll see in the dash cam video notices something. That tail light has a big missing piece to it. They can't find the children. Ultimately, Peggy comes home, a friend can take it down, and they bring the nephew home, and he is distraught. And then Peggy hears a knock on the door. It is the defendant and her father. They want to come in. They come in, open door, Mrs. Peggy, and they ask, can we go upstairs to John's room? And she's busy consoling her grandson. They go upstairs, they're upstairs for about 15 minutes. They come down, and quickly they leave. Now they got there from the defendant's father, drove his wife and the father to that house. But when they leave, they take two cars. They take the Lexus with the broken taillight with them back to the defendant's father's house. And you will learn that when police start getting some of the information, they learn about the broken taillight, they learn information that she had told people that she had hit him. They went down to see her. And on their way down, they decided they would get a warrant to take the Lexus. When they get down to Dighton, where the car is, you'll hear from Trooper Buchanan, who took a look and you can see the missing taillight. They went in and spoke briefly to the defendant. They took the car, they brought it back to Canton. And so, what you'll learn from the forensic evidence that will help with the science and data is that not only was the cell phone left behind, but also around that area, broken taillight was littered around John O'Keefe's body. Littered around that area. When they got to the hospital, they noticed there was a shoe missing. As time went by, snow melted, they dug with excavations, they found his shoe on a little berm on the border between the street and the grass. You'll learn days later when they did a plant excavation, they found his hat frozen into the ground. Ultimately, they would find over the course of 10 days that the snow melted almost every piece of that broken taillight in that area. The hat, the sneaker, the glass. When the defendant left Mr. O'Keefe behind, he took with her something of Mr. O'Keefe. It's called trace evidence. You'll learn on the back of her Lexus, around the taillight area, is John's DNA, and stuck to the side, grasping one last piece of John O'Keefe's hair. Now, John O'Keefe fell backwards and hit his head after he was clipped by the car. And you're going to hear from a very renowned doctor, a neurosurgeon, who has treated thousands and thousands of head injuries. And the wound on the back of the head, when he fell backwards, not the cracked the skull, it's called a basal fracture, it created an injury called counter-coup. After he was clipped by a car and fell backwards and hit his head on that hard rock ground, remember there's no snow, it's just a dusting at this point, the back of his brain hits the back of his skull and bounces up. When it bounces up, it leaves marks showing that impact. And this neurosurgeon will tell you, he's treated thousands of patients, that this injury, to a reasonable degree of medical certainty, is counter-coup caused by falling backwards and hitting your head. When the medical examiner for the state looked at it, they generally said blunt force trauma. They had it undetermined. And so we brought it to the renowned neurosurgeon who does exactly this. You're also going to hear from an active reconstruction. His name is Doug Welch. He does not work for the state police or local police. He was hired to take a look at this case and the data. He will come in and explain to you exactly what I talked about,
how the data from that black box coincides with the cell phone and the movements of the car, the moments before, during, and after the defendant struck John O'Keefe with her car. Now, just a few more things I want to share with you. There are 3 charges against the defendant in this case. The first one, second-degree murder. When most people hear murder, they instantly think shooting somebody, stabbing somebody, putting deliberate premeditation. Or I will instruct you on the law. I'm not going to trample in that area, but I can tell you clearly, we are not going to try to prove that Karen Reed tried to kill John O'Keefe. We're not going to try to prove to you that she intended or wanted him dead. That's not second-degree murder. What we'll prove to you is she engaged in an intentional act, driving back at him at that speed, in the storm, in the darkness, knowing that he had just gotten out of her Lexus. She intended that act, which could cause a plain and strong likelihood of death. That's what we'll prove to you for second-degree murder. Also, operating under the influence of alcohol, manslaughter will prove to you that she drove her Lexus recklessly. She hit John O'Keefe, and because she hit him and he fell back, she caused his death. The third charge is leaving the scene after knowingly causing death. Again, she hit Mr. O'Keefe with a car. She knew he was injured. She left him behind. And he died. That's what we'll prove. This case will come down to the science and the data. The science and the data that the cell phone is the best of historians. It doesn't suffer from intoxication. It doesn't suffer from memory loss. It doesn't suffer from emotion, pride, or prejudice. It is facts. It is data. And that facts and data will lead you to the truth in this case. But after Ms. Reed was charged, she began what you'll learn as a campaign. A campaign to make public statements. 2020, Nightline, Fox 25, a documentary. And we've had an opportunity to get many of her statements in the footage, and we're going to show much of it to you.
You said documentary?
Her statements to you will confirm what you already know from the science and the data. What you will already conclude from the facts independent about what she did that night. Her word is simply confirmed, and her judgment is sound. And you're going to hear from her own lips many of her statements, her admissions to extraordinary intoxications, her admissions to driving in the Lexus, her admissions to being angry at John that night. And I dare say her admissions that she told.
Told what? He talks so low. I don't know what
that
that
is. You clip one. You're going to hear the first of the statements that she made after she was charged.
I mean, I didn't think I hit him, but could I have clipped him? Could I have tagged him in the knee and incapacitated him? He didn't look mortally wounded as far as I could see, but could I have done something that knocked him out and in his drunkenness and in the cold didn't come to again?
And this would have been the moment you dropped him off at the party.
Yeah, would have had to.
Ladies and gentlemen, I simply ask you to follow the evidence, follow the science, follow the data. Ignore speculation, surmise, conjecture. Stay true to the evidence. It will lead you to the truth. That on January 29th, 2022, a very intoxicated defendant was angry and arguing about the relationship with John O'Keefe. And after the fight was over, she left, but she brought the fight back to him in the form of her SUV. She clipped him, he fell backwards, he broke his head, and then this man who helped, a lifetime of help, was left at the corner of that yard, left to die with no help. The facts, the data, and the evidence will bring you to the truth, and the defendant's own words will confirm everything you've already concluded.
All right, thank you, Mr. Jackson.
Oh, we're going back to
I
back.
have just a moment to readjust.
Sure, the court officers will be kind enough to help you.
that you said, firefighter said that you said, I hit him, I hit him, I hit him.
I said I hit him. It was preceded by a did and proceeded.
That's so weird. I can't get over this clip right here. The fuck?
Firefighter said that you said, I hit him, I hit him, I hit him.
I said I hit him.
All right, here we go.
Will establish above everything else 3 points.
I like that he talks louder and he's expressive and
There
like
was
Jackson.
no collision with John O'Keefe. There was no collision. There was no collision. John O'Keefe did not die from being hit by a vehicle. Period.
What did he die from then?
The facts will show that. The evidence will show that. The data will show that. The science will show that. And the experts will tell you that. You'll learn that the Commonwealth has pinned its entire case on a brazen and a flawed assertion that is untethered, unconnected to the facts and to the evidence. And their assertion is contrary to science. Because at the end of the day, folks, there was no collision with John O'Keefe. So how did we end up here? How does Karen Reed end up sitting in that chair on trial for an event that literally never happened? Well, the evidence is going to explain it. And it can be summed up in the following text message at the very beginning of this investigation. A text message of a now fired Massachusetts State Police officer named Michael Proctor.
Oh,
who's the lead investigator on this case.
They could bring that up. Oh,
and
shit.
He was talking about a fellow officer, a fellow cop, who owned the property where John O'Keefe's body was found. Text message with a buddy. Question, is the homeowner going to catch any shit? Answer, nope. He's a Boston cop too. That quote defines the lack of integrity of the Commonwealth's entire case, its entire investigation, and this prosecution. During the course of this trial, you'll learn much more about Mr. Proctor, why he said that, and what it really means.
Uh-oh. The shit back.
What you'll see and hear in this courtroom in the coming weeks is not just a story of a tragic loss. And make no mistake, John O'Keefe's death is and was a tragic and tragic loss.
But
the story you'll hear is about an investigation that was riddled with errors from the beginning, a rush to judgment, conflicted, and corrupted from the start. Corrupted by bias, corrupted by incompetence, and corrupted by deceit. Finally, it was corrupted by a deliberate effort to avoid and to cover up the very truth that you are seeking. You'll find when you hear the evidence that the Commonwealth's case is the literal definition of reasonable doubt. They won't be able to talk their way out of it. They won't be able to explain their way out of it. They won't be able to excuse their way out of it. And they can't meet their extreme burden of proof, which the court will tell you is beyond any and all reasonable doubt and to a moral certainty. Members of the jury, Karen Reed found John O'Keefe dead on the front lawn of a Boston police officer, Brian Albert, at 6 a.m. on January 29th, 2022. Picture the scene. Blood-curdling screams, ambulances, emergency lights on, fire engines, ladder trucks, paramedics, patrol vehicles, patrol cruisers, police officers, first responders, firefighters, all swarming all over Brian Albert's lawn, literally feet under his bedroom window. Yet Brian Albert, a sworn peace officer, a first responder himself, never came outside. Never went outside to see what the chaos was about, never went outside to see if he could assist a man in need, never walked outside his house to see if he could help a fallen fellow officer on his own front lawn.
Wow.
More shockingly, you'll learn that lead investigator for the Massachusetts Police, Michael Proctor, never set foot inside Brian Albert's house that day.
And one person stepped
Never
inside.
engaged in any investigation inside that house that day.
Well,
even though
yeah.
a party with much alcohol had just occurred in that house, and even though a Boston police officer was found dead or dying just mere feet from the front door on that lawn. He never secured the crime scene, never separated and secured witnesses. He never properly collected evidence. He never secured the evidence. He never searched for signs of a struggle inside or outside the home. He never properly canvassed the neighborhood. Michael Proctor never did any of these things, even though fellow officers of Michael Proctor's actually mentioned, in their words, not mine, that it looked like John O'Keefe may have been, quote, in a fight. You'll have questions about that conduct. During the course of this trial, you'll find that the Commonwealth will not have answers. You'll see from the evidence in this case that this case carries a malignancy, one that is spread through the investigation, it's spread through the prosecution from the very start, from the jump. A cancer that cannot be cut out, a cancer that cannot be cured. And that cancer has a name. And his name is Michael Proctor.
Oh.
Now, you didn't hear his name in the prosecution's opening statement. Not once. And I suspect that was probably by design. But make no mistake about it. The evidence will show in this case that Michael Proctor is the very definition of the Commonwealth's case. And he's also their Achilles heel. He was the lead investigator on the case officer, the architect of the entire prosecution. You'll learn there's not a single part of this case, folks, not a single part that he didn't touch, that he didn't direct, that he didn't orchestrate personally. Every single bit of it has his fingerprints on it. You'll learn that Michael Proctor was a longtime family friend of the Alberts. And he's been disgraced by his own agency, not by us, by the Massachusetts State Police. Investigated, suspended, and fired. The evidence will show that Massachusetts State Police found Michael Proctor guilty of bringing dishonor to the department for his conduct, not in some other case, not in some tangential case, in this case. The investigation of Karen Reed. Conduct that included bias in favor of his friends, the all-powerful Albert family, and bias against my client, Miss Reed, the outsider. Do you have any idea how hard it is for a state trooper to get fired? Well, the evidence is going to show that Michael Proctor earned it. Every bit of it. You'll hear that within hours of a Boston police officer being found dead on Brian Albert's lawn, Michael Proctor, the lead investigator, who had investigated exactly nothing up to this point, right at the beginning, made an early pronouncement that Brian Albert himself was not going to, quote, catch any shit, end quote.
Austin,
and that was for one reason and one reason only. He's a Boston cop.
Oh.
The evidence will show that Michael Proctor made this statement in a text conversation with his high school buddies. A text he never thought would see the light of day, certainly never thought we would get a hold of. And when he thought no one was looking...
Oh, God, what happened? Sorry, guys.
I want to take a step back, if I could, and spend the next few minutes talking a little bit more detail about what the actual facts in this case will show.
I want to play that part again. I want to hear what he said.
About finding the truth. He didn't care about finding the truth. In his world, his priority was to protect the brotherhood, to protect that blue wall, to protect his friends who were at the Alberts house that night. I want to take a step back, if I could, and spend the next few minutes talking a little bit more detail about what the actual facts in this case will show, not based on speculation, not based on surmise, not based on guesswork or conjecture, but the actual true facts that you will learn through the course of this trial. On January 28th, 2022, it was a Friday night. John and Karen had made plans to meet up with friends for drinks. It was a happy and normal night for them. They were affectionate, they were loving, they were in good spirits, nothing out of the ordinary. They started at a local watering hole called C.F. McCarthy's. You've heard that name before and you'll hear it again. And eventually they made their way over to the Waterfall Bar and Grill, another bar where they ended up. When they got to the Waterfall Bar and Grill, the Albert family was already there, already heavily drinking. You'll learn that this was no ordinary family, the Alberts. The Albert family was a well-known Canton family. Some might even describe them as a very powerful Canton family. Brian Albert was there at the waterfall. You'll hear that he's a longtime Boston police officer. His wife, Nicole Albert, was there with him. His brother, Chris Albert, a powerful Canton politician. He sits on the select board. The select board actually governs the police department, the Canton PD. He was there. His wife, Julie Albert, was there. Their daughter, Caitlin Albert, was there. His sister-in-law, Jennifer McCabe, was there. Her husband, Matt McCabe, was also there. They were all there drinking before John and before Karen ever arrived. You'll learn that a man by the name of Brian Higgins, also a law enforcement officer, and longtime friend, longtime pal of Brian Albert, he was also there. And the two of them, the two Bryans, had been drinking most of the night together. You'll see video footage from the waterfall, which will show you that Karen and John were happy. They were affectionate. They were caring. They were loving. Just business as usual, out on a date on a Friday night. But that exact same video footage which lead investigator Michael Proctor plainly chose to ignore that video footage. It paints a very different picture of Brian Higgins. You'll learn that Higgins had romantic designs for Karen.
Oh, yeah,
that becomes important. Brian Higgins had engaged Karen in flirtatious texts, but days earlier she had put a stop to it. She had ghosted him.
She was thirsting after him.
In other words, just ignored him. The evidence will show that the first time he saw her and was in her presence after being rejected by her was when she walked into the Waterfall Bar and Grill along with her boyfriend, John O'Keefe. At 11:58 p.m., just minutes before John ultimately arrived at the Albert residence, you'll see a video at the waterfall of an unsettling interaction, troubling interaction between Brian Higgins and John O'Keefe. And unlike the lead investigator, Michael Proctor, in this case, you won't ignore that evidence. As the bar was closing around 12 midnight, the Alberts invited everybody back to their house for a get-together to just keep the night going. And you'll learn that Karen and John ultimately pulled up to the house. They got out of the SUV to make sure they had the right address. You see, neither John nor Karen had ever been to 34 Fairview. They weren't even sure they were at the right address. And the evidence will establish that John got out of the SUV and went into the house. Let me say that again. The facts unequivocally, the data, the science, the witnesses will all unequivocally establish that John O'Keefe went into the Albert home that night. Eyewitnesses and forensic data will establish that fact. When he didn't come back out, you'll learn that Karen grew increasingly frustrated. She got upset. She was left alone in a car, in the cold, in the middle of the night, with the car idling. John had gone into the house. She expected him to come right back out, and when he didn't, seconds turned into minutes, and minutes started to clock away. She left John a voicemail, then another voicemail, voicemail after voicemail after voicemail, text messages. But he was unresponsive. He didn't pick up a single call. He didn't respond to a single text. The longer he didn't respond,
because he was dead,
the more upset she got. The Commonwealth will intimate, as they already have in their opening statement, that these voicemails are evidence that the two were fighting. The actual evidence in this case, however, will show the exact opposite. You'll hear that Karen was very agitated. You'll hear some voicemails where she's swearing. You'll hear voicemails where she calls him names. There's name calling. But you'll also hear the context of those voicemails. And every single one of them, every single one of those voicemails was left for John after he failed to come back out of the house, after he failed to respond to her voicemails and to her texts. Karen believed John had just left her sitting there, grabbed a beer, was partying with his friends. The evidence will actually show that John and Karen never had a crossword, not a single crossword that entire evening before he left that SUV and went inside the house. And you will learn what Karen had absolutely no way of knowing at the time. It wasn't that he wouldn't respond to her. It's that he couldn't respond to her. And the evidence will show you why. Let's talk about that. We'll introduce you to a doctor named Elizabeth Lopesada, a renowned forensic pathologist, a medical examiner, and a professor at Brown University. She will tell you that the injury to the back of John's head, first of all, was immediately incapacitating. And that has meaning. At the moment he suffered that fatal head injury, he couldn't walk, talk, grab his phone, cry for help, nothing. He was completely incapacitated, completely unconscious from the moment he suffered that injury. He was completely still and incapable of interacting with anyone or anything. But the doctor will tell you something more, and just as important. She'll tell you that John O'Keefe did not suffer from hypothermia, as the Commonwealth will undoubtedly allege.
What?
His body showed no signs of it. No frostbite, no cold-induced injuries to his organs, no damage based on cold or frost. Ladies and gentlemen, the scientific evidence and the medical evidence will establish that John O'Keefe had to be injured somewhere else, somewhere warmer, and his body had to have been moved into the cold.
Oh! But why? Why though? Why now, bro?
And that's where, ultimately at 6 a.m., Karen found him the next morning.
Why put him outside in front of the house?
John did not have a single injury consistent with being hit by a car. Let me say that again. The evidence will establish that John did not suffer a single injury on his body consistent with having been hit by a car. Not one. You'll learn that John's torso, his ribs, his chest, his arms, his hips, his legs, his knees, his ankles, his feet, all of them. No broken bones, no fractures, no contusions, no torn ligaments, no internal injuries, not even a bruise. Nothing consistent with a car accident, despite the Commonwealth's contention that he was slammed into by a 6,000-pound SUV. Not a bruise. Dr. Lopesada will tell you with medical certainty that, in fact, John was not struck by a vehicle. Medically and scientifically, he could not have been struck by a vehicle. Therefore, as I said, there was no collision. She will tell you that the patterned abrasions on John's right arm, the patterned abrasions you see over my left shoulder, they're not the result of being struck by a car or a taillight. You'll take one look at these injuries and you'll agree with Dr. Lopesada. The evidence will show that these injuries are from an animal, like a large dog. Like the large dog that was inside the Albert house that night.
Poor Chloe, still catching heat.
You'll learn that Brian Albert has actually admitted that his large dog, the family dog, is, quote,
violent,
not good with strangers. And of course, John, never having been to the house before, was a stranger that night. You'll also learn that oddly, very oddly, after having their family pet for 7 years, a short time after this incident, the Alberts got rid of that dog. They called it rehoming her. But she was gone. Dr. Lopesada will also tell you that the injury to John's head was not the result of falling backward onto a flat lawn, cold or otherwise. Rather, Dr. Lopesada will tell you with medical certainty that the injury pattern to his scalp was produced by an impact from a raised or ledged surface, a surface that does not exist on Brian Albert's front lawn where John was found. The medical evidence will establish no hypothermia, no injuries from a car strike, no collision with a motor vehicle. And forensic analysis of John's cell phone, Mr. Brennan mentioned that in his opening statement. The Commonwealth's own expert will ultimately support the exact facts that I just told you, including the temperature data. John O'Keefe was injured someplace warmer, and he was moved. That alone is reasonable doubt, but there's much more. You'll also learn that there were many people at that after-hours gathering at Brian Albert's house who would have left by the front door just feet from where John O'Keefe's body would have ultimately been, had he actually been there, right after 12:30 a.m., which is what the Commonwealth's claim is. There were nearly a dozen people who walked out that front door directly adjacent to the precise spot where John O'Keefe would have been lying. Not a single person, not one, not a single person, saw a 6'2", 216-pound man laying sprawled in the front lawn in dark clothing on a light white dusting of snow. Not one. Then the evidence will also show that every one of those same people drove by that same spot, not walked by it, drove by it to leave the house, and still not one of them saw John laying in the yard when they left between 1 a.m. and 2 a.m. in the morning. But you know who else you'll find never saw a body on that lawn? The snowplow driver, a completely independent witness charged with plowing the streets in Canton that night. You'll hear that Michael Proctor, oh, he's not done yet, Mr. Proctor. You'll hear that Michael Proctor wrote a report where he claimed that Fairview had not been plowed that night. You'll learn that that was completely false. That was a lie. Michael Proctor did not want any more witnesses. He didn't want the truth, and he falsely claimed that the road was never plowed. You'll learn that he wouldn't look for the plow driver, but we did, and we found, and we'll introduce you to, Brian Loughran. He plowed Fairview that night, and what he's going to tell you is that there was no body on that lawn at 2:30 in the morning. You'll learn that Brian Loughran passed by 34 Fairview, traveling right next to Brian Albert's front yard, and at 2:30 a.m., John O'Keefe was not there. But you'll see that the plow driver also provides some other troubling information, troubling testimony for the Commonwealth. You'll learn that after making that pass at 2:30 a.m., he showed up with his plow an hour later. He stopped at the entrance of Fairview. He was looking up Fairview to decide whether or not to plow it, but he saw an obstruction. At 3:30 a.m., he looked down the street, and in the very spot precisely where Karen would later find John's body laying at 6 a.m., there was a car parked in front of it, a Ford Edge.
Ooh, whose car is that?
You're going to ask yourself, who's moving a car at 3:30 in the morning into a blizzard on the side of the road? You'll learn that Michael Proctor, the lead investigator, intentionally ignored this fact as well. He did no investigation to find out who owned a Ford Edge, but again, we did. And the evidence will establish that a Ford Edge happens to be a favorite model of the Albert family. More than one Albert owned a Ford Edge at the time. You'll learn that those facts will add to the mounting and the overwhelming evidence that there was no collision and John O'Keefe's body was moved onto that lawn. You'll find that this is yet additional reasonable doubt in the case. You'll be introduced to science and physics, even from the Commonwealth's own experts. That science will establish that Karen Reed's SUV was not damaged by hitting a pedestrian, and conversely, John O'Keefe's injuries did not come from being struck by a vehicle. The Commonwealth mentioned triggering events, but what you'll actually learn from the experts, some of them the Commonwealth's own experts, is that a triggering event is not evidence of an accident. It does not evidence a collision. That's why we're here. A collision. And there's no evidence of one. Zero. You'll also find that those exact sort of triggering events that the Commonwealth will rely on are relatively commonplace on Karen's SUV, and none of them are associated with a claim of a collision. Folks, the science will not lie, and the physics cannot lie. And that science will tell you with certainty there was no collision with John O'Keefe. You'll add that to that rising mountain of reasonable doubt. I want to take you back to the night in question, January 29th, for just a few minutes. Remember, Karen had gone home after dropping off John and John walking to the house. While Karen was asleep at home with John's 13-year-old niece, what were the people who had been at Brian Albert's house that night? What were they doing? While she slept, what you'll find and what the evidence will show is that they were extremely busy. You'll learn that after a long night of heavy drinking, Brian Higgins left the Albert residence, but he didn't drive home. Rather, he drove over to the Canton Police Department, where he kept an office at about 1:25 a.m. Not a Canton police officer, but he kept an office there. Why go back to his office at 1:25 a.m.? Why go back to the Canton Police Department at 1:25 in the morning on the night of a blizzard? You'll learn that while there, Higgins made a call at 1:30 a.m. Higgins will later deny that he made that call. You'll find that curious. And his explanation for that late night visit to Canton PD, you'll find that it changes nearly every time he's asked about it. You'll learn that after everyone left Brian Albert's house, Brian Albert actually claimed he had no contact with anybody else except his wife. No contact. Until he woke up the next morning. So he says. Then you'll learn that that, too, is a complete lie. His phone records establish that he placed a call to none other than Brian Higgins at 2:22 a.m. shortly after Higgins completed that late night visit over to Canton PD. You'll wonder, what did they possibly need to talk about at 2:22 a.m. that night? The evidence will establish that Brian Albert called Brian Higgins first. Brian Albert then disconnected that call when Higgins didn't answer it. Seconds later, Brian Higgins returned the call. Brian Albert then did answer that call. They spoke for 22 full seconds, had a conversation, then they both hung up their respective phones. You'll learn that when they were asked about these calls and conversations, both Brian Albert and Brian Higgins lied about it. Both of them. They said they never had a call with each other. But then ultimately, when they were confronted with their own cell phone records and they could no longer deny the calls, they were asked independently, explain yourself. And they both came up with the exact same explanation. A butt dial.
Butt dial.
The evidence will make you question, why did Albert and Higgins speak at 2:22 a.m.? And why did they both try to cover up that phone call? You'll also learn after this incident, and within days of one another, both Brian Higgins and Brian Albert, both police officers, both trained investigators, got rid of their phones. Both of them. And what else you'll learn Brian Albert got rid of? Shortly after this incident, Brian Albert got rid of his house. The whole thing. Just sold it. His childhood home, a home that had been in the Albert family for generations, he literally sold it mere months after this incident. Dog rehomed, phones destroyed, house sold. You'll learn that all these things happened shortly after the incident where John O'Keefe was found unresponsive and dying in Brian Albert's front lawn. And you'll also learn that Michael Proctor looked the other way. He did not investigate any of what I'm telling you. He pre-selected Karen Reed from the start, and he ignored everything and everyone else. Let's get back to what was happening with the others while Karen slept. What you'll learn during this trial is that Brian Albert's sister-in-law, you've heard her name before, Jennifer McCabe, she was at the waterfall that night and she was over at the Alberts' house that evening as well. She left the after-hours gathering about 2 a.m., a little before 2 a.m., got home around 2 a.m. And you'll learn that according to the Commonwealth's own evidence from a forensic software program called Physical Analyzer made by Celebrite, it's considered the gold standard for forensic tools, you'll learn that a Google search was discovered on Jennifer McCabe's phone. A Google search that Michael Proctor and his investigators never revealed to us. But we found anyway. A Google search that was time-stamped, according to their own data, at 2:27 a.m., 5 minutes after that 2:22 a.m. call that Higgins and Albert denied having. And that Google search on Jennifer McCabe's phone read, "Hoslong to die in cold." Hoslong to die in cold. Now, she misspelled the first word. Hos is supposed to be how, but the meaning's the same.
That was the bug.
How long does it take to die in the cold? Time-stamped 2:27. And then that search was also noted by the same Celebrite program as having been deleted. The evidence will force you to ask, why is there a search on her phone?
Oh.
Why is it logged at 2:27 a.m.? When the Commonwealth claims that she first learned of John's death and where his body was hours later at 6 a.m. So what you'll learn is that while Karen slept, here's what was actually happening by some other very busy bees.
Tell it.
1:25 a.m., Brian Higgins makes an unexpected visit to Canton PD. 1:30 a.m., he makes a phone call that he later denies ever making. At 2:22 a.m., Brian Higgins and Brian Albert talk. They both deny and lie about having made that phone call. 2:27 a.m., 5 minutes later, a Google search appears on Jennifer McCabe's phone, Hoslong to die in cold, hours before John's body was ever discovered. A Google search she denies making, and that she later, or at least it was later logged as deleted. Meanwhile, at 2:30 a.m., the plow driver confirms that O'Keefe's body was not on the lawn of Brian Albert's house, not at 2:30 in the morning. And at 3:30 in the morning, that area was obstructed by a Ford Edge like the one the Albert family liked to own. The evidence will show in the meantime, Karen dozed in and out of a fitful sleep for the rest of the night, only to awaken just before 5 a.m., and that's when she realized, in a panic, John had never come home. And you'll see, it wasn't like John to not come home. That morning, you'll see and hear evidence that Karen's emotions had morphed. It'd gone from frustration and anger, which you'll hear in the voicemails, to abject fear. Fear that something bad had happened. The evidence will establish by this time, Karen was panic-stricken. She had a feeling something was very, very wrong. She was unable to get a hold of John. Karen went to go look for him. She got in her Lexus and she backed up to leave her garage at One Meadows. You'll hear a lot about that address, One Meadows. That was John's house where Karen was staying. She backed out of the garage, and during the course of the trial, you'll hear that she actually struck another car with that right rear taillight. During the course of this trial, the Commonwealth is going to desperately claim that Karen Reed's taillight was actually damaged by hitting John O'Keefe. They'll have no evidence of it, mind you, none, but they'll make the claim. We'll show you a video of exactly how that taillight was originally damaged, or exactly what happened at 5:07 in the morning. The facts will show that it was damaged in John's own driveway at 5:07 when Karen backed up and made contact with another car in the driveway. This is 5 hours after she dropped John off.
That's convenient.
And he went into the Albert residence. As a result, the taillight was minimally cracked, but it wasn't completely shattered or damaged or broken. And that's the condition of the SUV when Michael Proctor got a hold of it. That becomes important. You'll hear from an independent police officer, an eyewitness to the damage on that SUV, someone not connected to Michael Proctor or under his control. And he'll tell you that he saw the taillight damaged before it was in Michael Proctor's possession, but it was not completely shattered. And you won't have to speculate how that taillight got cracked originally. You'll see it for yourself. It's on video. You'll learn that part of the reason that Karen's Lexus hit that car at One Meadows is because she backed out looking for him at a time when she was absolutely panic-stricken and grief-stricken. Where was John? Why hadn't he come home? What had happened to him? Is he hurt? Is he passed out somewhere? Her mind was reeling. The evidence will establish she wasn't giving anything away. Everything was on the table. What could have happened to John? You'll learn that when she woke up, and he still wasn't home, she was just racking her brain for what could have happened to him, and she was worried about possibly the worst. He had gotten out of the car, he'd walked to the house, she was confused, and later, when she found him at 6 a.m. on the lawn, where she last saw him going toward the house, her mind started reeling, oh my God, did a plow hit him? Did I hit him? Could I have hit him? What could have happened to him? And that video clip that you saw, out of context, when she said the words, he did not look like he was mortally wounded, she's not talking about at midnight. She's talking about at 6 a.m. when she found him. That's what she was talking about. Your job will be to make sure that the evidence isn't presented to you too cute by half. She was saying all those things. Did a plow hit him? Could I have hit him? Did I hit him? She was saying that to herself and to other people. And the Commonwealth, very obviously, will try to seize on that panic and twist this into some admission. But here's the actual truth. That's not a confession. Could I have hit him? Did I hit him? Could a plow have hit him? That's a person trying to make sense of an unexplainable circumstance, a natural concern of a bereaved significant other. A woman desperately trying to piece together what could have happened on this tragic night. John didn't come home. And the evidence will show that Karen Reed never said, I hit him. Never. Not in the background of the 911 recording, not on any dash cam video, not on any audio, not on any police body cam, not to a first responder. It's never mentioned in a single report. It's never reported in a single report from January 29th, not by one person, because it never happened. The evidence will show that the evidence will show that there were at least 13 members of law enforcement or first responders and 2 civilian witnesses that were intently focused on what was happening at that scene. They were all over the lawn. They were all over Karen. Officer Seraph, Mullaney, Good, Lank, EMT Nuttall, Flamati, Kelly, Walsh, Woodbury, Whitley, Becker, Robery, McLaughlin.
Hey, nobody documented nothing.
Kerry Roberts, Jennifer McCabe. They were all there, watching and listening. On January 29th, when John O'Keefe was found, not one first responder reported having heard Karen Reed say the words, I hit him. Not one. Not one civilian reported having heard Karen Reed say, I hit him. The facts will show that the first time this improved statement was ever claimed to have been made was some 24 hours later by a single EMT in an interview. Now listen to this. In an interview coordinated by a Canton police detective named Kevin Albert. Brian Albert's brother. And remember, Chris Albert, the other brother, is a board selectman to whom the Canton Police Department reports. And what's more, you'll learn that Katie McLaughlin, that's the EMT, that's the single EMT, the first person to have claimed to have heard this unrecorded and unreported statement, is years-long close personal friends with a young woman named Caitlin Albert. You heard that right. It's Brian Albert's daughter. During the course of this trial, you'll become familiar with and you'll realize that the Alberts are indeed a powerful and indeed an influential family. And that will mean something. You'll learn that there are other major problems with the prosecution's case. The evidence will establish that Michael Proctor himself, the lead investigator and architect of this entire case, has a long-standing and personal relationship with the Albert family. Yes, that same Albert family. His sister was close friends with Julie Albert. He personally sat at head tables at weddings, or at a head table at weddings with the Albert family. He entrusted the Alberts with babysitting his own children. You heard that correctly. And yet he was the lead detective assigned to investigate the circumstances of a Boston police officer laying dead on the Alberts' front lawn. That's not just bias, you'll learn. That's not just coincidence. That, folks, is corruption. And you'll see how far it went. Michael Proctor was alone with all the critical evidence in this case, along with Karen Reed's phone, along with John's phone, along with video footage, along with the taillight material, alone when he claimed to recover evidence from 34 Fairview. He wrote the search warrants, he transported the evidence, he secured it, he submitted it, he did it all. That's Michael Proctor, and he did it without any reasonable oversight. You'll see during the trial that he intentionally lied and fabricated evidence during the course of this investigation. He lied in reports, warrants, he lied under oath. He lied about the time that he actually secured Karen Reed's vehicle. Why? Why would he lie about that? The evidence will give you the answer. He lied because he did not want it revealed that he had access to that vehicle and he had access to that taillight before any taillight fragments were found at 34 Fairview. Appreciate that. He had access to the vehicle before a single piece of taillight material was ever found at the scene. You'll find that there were two searches. The first and second search found zero. Nothing. Nothing around John's body. Nothing in the street. Not one piece of taillight fragment. But once Michael Proctor had that SUV and had the taillight in his custody and control, suddenly items started magically showing up. And not just a few items.
Oh, shit.
46 pieces of bright red taillight laying in the snow. Supposedly found in the exact same spot that was searched not once, but twice by independent officers. It came up with zero. To be clear, you'll learn that before Michael Proctor had access to that taillight, not a single piece was ever recovered at 34 Fairview. That will become vitally, vitally important. And what about those shards of plastic, by the way? What about this DNA that the Commonwealth mentioned? They're going to try to dazzle you with talk of DNA because it sounds so scientific. The DNA was on the taillight. But you'll learn that there was no DNA on the actual shards that they claim came in contact with John's arm. None. There was no blood, no tissue, no skin, no DNA on a single shard of plastic that they claim cut deep abrasions into John's arm, the arm that you saw overhead. The DNA that was actually found, the actual science will show, was found outside of the taillight housing where anyone with access to that vehicle would have touched. And it wasn't just one male's DNA. In that exact same sample, there were 3 men found. John and 2 unidentified males. So unless the Commonwealth is going to shift their theory that that SUV hit 3 men that night, their entire theory falls apart. And speaking of DNA, the evidence will further establish that John O'Keefe's shoe, the one that he was wearing when he was found, was sampled. And that DNA revealed 5, count them, 5 unidentified males. Recall that the evidence will establish independently that John was injured someplace warmer and had to be moved onto that lawn. 5 unidentified males touching that shoe. You'll also learn that you are not the first person, not the first to hear about the Commonwealth's theory of this case, that John was hit by an SUV. That's their theory. The Commonwealth presented this exact same claim to their own medical examiner, a woman by the name of Dr. Irini Scorti-Bello. And you'll learn that after reviewing what's called a law enforcement accident notifier, with law enforcement's theory of the collision written in it, defined in it, after conducting the autopsy herself, after examining John's injuries in detail, she refused to conclude that John's death was a homicide based on the Commonwealth's presentation and their theory. That's right. The Commonwealth's own medical examiner will not deem the manner of death in this case, a homicide. She won't do it. But they're nonetheless back again trying to present the exact same theory to you in this trial. Again, the evidence will show that that is reasonable doubt. Throughout this trial, the Commonwealth will try to convince you of paranormal events, phones calling themselves, messages deleting themselves, Google searches made and then unmade, evidence magically appearing and evidence magically disappearing. But all that smoke and all those mirrors will not ever reach their burden. because that's what this case is ultimately about. It's about the Commonwealth's burden of proof. You'll learn that during the trial, the Commonwealth bears the highest burden known to our justice system. They must prove every element of every charge beyond a reasonable doubt and to a moral certainty. And you'll learn that moral certainty means the highest level of certainty known in human affairs. It's not a small thing. And they're not going to be able to do that. Not when every piece of this case was handled by a disgraced investigator with a motive to protect his friends, not when the physical evidence contradicts their very theory, not when their own medical examiner won't call this case a homicide based on the exact theory that they're presenting to you, not when the conduct of those in the House and the utter lack of investigation speaks volumes about those who actually have something to hide. By the end of this trial, you'll conclude that Karen Reed is not guilty of hitting John O'Keefe with her SUV. There was no collision. She's the victim of a botched and biased and corrupted investigation that was never about the truth, folks. It was about preserving loyalty. You'll find that this case is the very definition of reasonable doubt. And at the end of this trial, we'll ask you to return the only verdicts, all three of them, that are consistent with the evidence, the science, the truth, and justice. Not guilty, not guilty, not guilty.
Okay.
Thank you.
We'll put on a
Mr.
show.
Jackson, folks, why don't we take our morning recess?
Okay, they're gonna take a morning recess. We're gonna do a new stream now. Steven Stearns is in court. He has a court appearance happening right now. The child killer, Florida child killer. So we're gonna jump on that. I already mostly made a thumbnail already. My thought about opening statements. Brennan, the prosecution, they said he was really good. I thought he did a decent job with the timeline. Interesting that they mentioned the phone. Cool that they're going to use Karen Reed's interviews. Action Jackson. I think he did really good. Action Jackson did really good. And I feel like he's kind of keeps people more engaged, and he he puts emphasis on things and makes a lot of, facial expressions and hand movements and easy to understand and clear when he's talking. So, it's going to be an all-out war with that trial. Steven Stearns back in court. We got to follow up with that Florida story where it's a really sick story. Oh, I didn't put a thumbnail on it. Oops, let me do the thumbnail. I thought I added it. Sick story. Child killer. Okay, I think I'll leave it like that. Yeah, child killer in courtroom. Let's get this thing rolling. I'm gonna transfer you guys right now. If you'd like to come and join me. So redirect. I'm gonna drop the link in the chat too in case it doesn't work. Some people will sometimes tell me it doesn't work. All right, moving on over.